as to qualify the continued progress of the present impeachment process. Now, honorable senators, ladies and gentlemen, the question of what constitutes a preliminary objection was well set out in the leading case of Mukisha Biscuit Manufacturing Company Limited versus West End Distributors, contained in the 1969 EA at 696. And it states as follows: a preliminary objection consists of a point of law which has been pleaded or which arises by clear implication out of pleadings, and which, if argued as a preliminary point, may dispose of the suit. Examples are an objection to the jurisdiction of the court, or a plea of limitation, or a submission that the parties are bound by the contract giving rise to the suit to refer to the dispute to arbitration. A preliminary objection raises a pure point of law, which is argued on the assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained or if what is sought is the exercise of judicial discretion. A preliminary objection does not need evidence to be adduced as proof of its existence. It is limited to points of law and cannot be raised if a fact has to be ascertained. Now, honorable senators and ladies and gentlemen, drawing from the decision in the Mukisha Biscuit case, the issue of whether the impeachment of the governor met the threshold required under Section 33(2) of the County Governments Act, Cap 265 of the laws of Kenya, is a factual question that is contested. The governor has raised questions on the manner and integrity of the voting process, which calls for the Senate to interrogate the documentation and pleadings presented before it by both the County Assembly and the Governor of Kericho. It is noteworthy that counsel for the governor, in their own submissions, repeatedly asserted that the contestation was based on the facts of what actually transpired. Indeed, the governor has called the 18 members of the County Assembly whose vote is contested as witnesses to these impeachment proceedings. No summary determination of this matter is possible without these witnesses taken to the stand to give evidence and being subjected to cross-examination in the usual manner. The factual question of the number of members of the County Assembly who voted for the impeachment motion is a matter that calls for determination by the Senate. The only way for the Senate to determine these questions is to receive evidence on the matter, evaluate the same, and make a finding one way or the other based on the preponderance of evidence. It is important to recall that the Senate did, on the 14th of October 2024, vote to uphold a preliminary objection raised by the Governor of Kericho on the ground that the threshold required for removal of the governor from office by impeachment, provided for under Section 33 of the County Governments Act and Standing Order 74 of the Standing Orders of the County Assembly of Kericho, had not been met. In those proceedings, there was no dispute as to the fact that the documents submitted in evidence by the County Assembly included a list of 31 out of 47 members of the County Assembly of Kericho that had voted in favor of the motion for removal from office by impeachment of the Honorable Governor of Kericho. The question for determination by the Senate in those impeachment proceedings was whether the two-thirds constitutional threshold was 31 or 32 members of the County Assembly. There was no dispute or contestation between the Governor and the County Assembly as to the following facts. A, the County Assembly of Kericho has 47 members, and B, only 31 members of the County Assembly voted in favor of the impeachment motion. The Senate, in those proceedings held on the 14th of October 2024, was only left with the task of determining the legal question as to whether the two-thirds constitutional threshold was 31 or 32 members of the County Assembly. That determination did not require the production of any evidence. On the 14th of October 2024, the Senate, by its vote, determined that the two-thirds threshold is 32. In the current impeachment proceedings, there is contestation between the Governor and the County Assembly as to the following facts. The members of the County Assembly who voted in favor of the motion, and B, the transparency and integrity of the electronic voting platform deployed on the 14th of August 2025. This is not to say that the objection raised by the Governor is not important. It is indeed fundamental. In fact, it is of great importance. It will set a very dangerous precedent if the Senate will be sent on a wild goose chase to conduct impeachment proceedings and vote on charges which are defective ab initio, and on the ground that no lawful impeachment was undertaken. It therefore means that the Senate must make a determination one way or the other whether the threshold for impeachment was met. The real question before us, therefore, is only the stage at which that question is mature for determination. I therefore rule that since this matter of fact requiring the adducing of evidence, it will be determined by hearing both parties and entertaining evidence that they have in respect thereof. This preliminary objection is accordingly disallowed for being premature at this stage. In light of the importance of the question, though, the Senate shall determine the disputed facts prior to making a determination on the impeachment charges. I therefore further rule that at the conclusion of the impeachment proceedings and prior to the voting on the charges, the Senate will pronounce itself on its finding on the matter of the threshold and whether it was met. In the event that the Senate finds that the two-thirds threshold of 32 members of County Assembly was not met, then the impeachment proceedings shall immediately determine, and the Senate shall now proceed to determine the impeachment charges. If, however, the Senate finds that the two-thirds threshold of 32 members of the County Assembly was met, that is, after hearing the evidence, then the Senate shall proceed to determine if the impeachment charges have been substantiated by voting thereon. The preliminary objection is therefore fails, as the same shall now be subsumed in the main hearing of the impeachment proceedings. It is so ordered. Thank you. Next order.